Thanks for joining us, everyone. This is our California employment law update for 2025. We're excited to join you all today for a discussion about all things California employment law. This is the beginning of our employment webinar series for 2025. We have a whole year of slated webinars for you. Today we'll be I'm joined by my colleagues, Andrea Chavez and Samuel Rose. We will be discussing California law update, so you know what things have gone into effect over the last few months and what to expect for the coming year. We've included a few bio slides so you have our background information in case you want to reach out to us with any questions or things that go beyond today's webinar. Just to introduce myself, my name is Megan Shaked. I'm a partner out in our San Francisco office. I'm in our firm's employment practice group as well as our OSHA practice group. So on the employment side, I handle administrative and litigation matters as well as advice and counsel for employers on all things California employment law compliance. Joined today by our senior counsel, Andrea Chavez, who has similar practice, is in both practice groups and has extensive experience counseling employers and handling litigation matters as well. And then we also have our associate, Samuel Rose. Andrea and Samuel are both located in Southern California, but handle things all throughout the state. Again, representing employers on both employment matters and workplace safety. Just to give you a high-level overview of what we'll be covering today, we're going to give you some legislative update for those of you who are unfamiliar with the legislative cycle in California. The legislature has until the end, kind of the middle fall, to finish their legislative cycle. And then the governor generally has until the end of around September to either sign or veto legislation. So we see a flurry of activity at the end of the year, and then the new legislation goes into effect generally January 1st, unless it goes into effect earlier. So we'll go through the legislative updates in case anyone missed anything and needs to make some updates to their policies or procedures. And then we'll go over some important court decisions that we've seen over the last little while to make sure that you are aware of those as well. Sam will give a brief NLRB update, the National Labor Relations Board update, since that can impact California employers as well. And then we'll wrap up with takeaways. We'll do our best to answer questions as we go along the way, but if you don't get your questions answered, we'll be sure to follow up with you, or feel free to reach out with any questions about today's presentation or anything else that comes up for you. And with that, we will go ahead and get started with our legislative update. So the first topic we wanted to cover is PAGA reform. This is a really, really big change in the California wage and hour space. For those of you who don't know what PAGA stands for, it's the Private Attorneys General Act in California. It was enacted in 2004. And it essentially allows an employee to stand in the shoes of the state and collect penalties for labor code violations for themselves and all of the aggrieved employees, so similarly situated employees. It's kind of thought of as like a lighter class action. It doesn't have all of the formalities of a class action, and it works a little bit differently, but it is similar in the sense that the PAGA plaintiff can collect penalties on behalf of employees other than just themselves. And originally, it allowed for the penalties to be split between the state agency, which is the LWDA, and the aggrieved employees, 75%, 25%. And there have been some really huge changes to how this scheme works that should be close some of the gaps in the PAGA scheme that were most challenging for employers and were seen as unfair and unworkable in some ways, and were things that got a lot of criticism about the PAGA statute itself. So we're going to go through some of the really high level changes and then talk about, what we think how we think this might impact PAGA litigation moving forward. Certainly, if you have specific questions, reach out, because a lot of the detail, can matter. It can impact whether or not your case is impacted by this reform. So first, we wanted to highlight that the standing rule has changed, and now an aggrieved employee must personally suffer each alleged violation within 1 year of within 1 year. So there used to be some ambiguity about what the statute of limitations was, and now it's clear that it's 1 year. There are some exceptions, so that's something to check if you're in active litigation. There's also been an increase in opportunities for cure, including early evaluation of cases. So it used to be that once a case was filed, there were some restrictions in what employers could do moving forward. There's a lot more opportunities for early evaluation and addressing concerns of potential violations early on as a way to limit damages down the line. Another really important part of the change is that the penalty share has changed. So now, rather than a 75-25 split, you now have 65% going to the state agency and 35% going to the employee share. So there's been an increase in the penalties that will actually filter down to the employee, the group of aggrieved employees who are covered by a PAGA settlement or ultimate liability. There's also been clarification. The law allowed for a higher penalty. There's some variation in the penalty that might apply based on the violation, but where the statute isn't clear, there's a $100 penalty, or it could be this higher $200 penalty in certain circumstances. But the PAGA reform clarified that higher penalty is reserved for employer conduct under certain circumstances. So it has to be malicious, fraudulent, or oppressive. And it has to be where in the last 5 years, either the LWDA or a court determined that the employer policy or practice giving rise to the violation was unlawful. Only then does that higher penalty come into effect. Another really big part of this PAGA reform is penalty reductions and penalty caps in certain circumstances. So if you think about that $100 set statutory penalty per violation per pay period, there are certain circumstances now where that penalty can be reduced. And some examples are, we saw a lot of PAGA litigation around technical violations stemming from a wage statement. And something as simple as, the employer name may be misspelled or the address is incorrect. So the reform provides that there can be a reduction where the employee can still determine from the statement itself the information that's required to be in the statement, but even if there may still be a technical violation. There's similar things where the employee is not, confused or misled by the correct employer entity. That's again, if the employer name is there on the wage statement as it's supposed to be, but maybe there's a typo. So you'll see some additional examples here. There's also allowance on the right-hand side of the slide. It explains these penalty caps. And these are available under certain circumstances. For example, when corrective action is taken within a certain amount of time of receiving a notice of potential PAGA violations, or even after that notice, if there's been cure, there's additional provisions for caps on the penalties. There's also been clarification that you can't get stacked penalties. So it used to be that you can get, if you have for example, a wage statement violation, you might also have all these other penalties that stem essentially from the same error. And so there's been a limit placed on that. There's also a clarification that if you're an employer who happens to pay every week rather than every other week, that there's an adjustment so that you're not getting penalized doubly just because of that reality of your pay schedule. So whether or not you may be faced with PAGA litigation currently, this is a really good reminder that payroll audits and other wage and hour audits remain critical to understand your compliance obligations and make sure that you're managing against the risk of wage and hour litigation. It's also a really good reminder to be reviewing your written policies periodically to make sure that they're in compliance, as well as making sure that those who may be enforcing wage and hour provisions or training on policies and procedures, supervisors or managers and the like, really understand the rules and understand how they should be implemented to make sure that everything is being done correctly. You know, it remain this like I said, this PAGA reform is a pretty huge change to the wage and hour landscape in California. And so as these new matters kind of work through litigation, we're curious to see how this might impact strategy for the plaintiff's bar, strategy in the litigation, whether it has any impact on settlement value of cases, which we expect given some of those allowances for penalty reductions and penalty caps, and how, if any thing, there needs to be the courts or the legislature weighing in again to close any gaps in understanding between maybe what the reform was intended to do and how it's playing out in reality. So we're keeping a really close eye on this and happy to discuss with anyone if you have questions. Just one other note in case this applies, we see a lot of legislation in California that's industry specific. So we try to include things where we think our audience might be interested, but for your industry, certainly keep an eye out in case there are any laws that would apply to your industry specifically. This is just one example that there's been an extension for PAGA for those in the construction industry. So if that applies to you, that may be something to take a closer look at. And with that, I think I'm passing off to Sam to continue chatting about some new legislation.
Thanks, Megan. So we'll go through a couple other bills that took effect at the beginning of this year. Most of them are fairly minor, but just things that could fall through the cracks if you're not paying attention to current legislation, and that could ultimately cause some problems down the line. So just want to keep you guys up to date on these latest laws. The first one is a workers' compensation notice requirement. California law already required certain types of notices related to workers' compensation, but the legislature passed a law that took effect January 1st that requires that posting to include a notice specifically that employees are entitled to consult an attorney related to their workers' compensation issues. So just want to make sure that your workers' compensation notices that you might have posted in your workplace are up to date and compliant with the new law. The next posting sort of bill that passed out of the legislature had to do with whistleblower law. It already required employers to post employee rights and responsibilities related to any whistleblower law. But this bill that took effect January 1st required the labor commissioner to develop a sort of template posting that employers could use that would automatically be deemed compliant with California law. That posting is now available on the labor commissioner's website. So if you want to ensure that your postings are compliant, you can compare it to that labor commissioner posting or just use the labor commissioner's draft posting that's on their website. The next big change is sort of deadlines related to summary judgment motions. So all the deadlines related to when you have to file the briefs in a summary judgment motion have been pushed forward. So from the time that your attorney basically reserves the hearing date for your summary judgment motion, you have a shortened amount of time now to draft that brief, which means you have a shortened amount of time now to make sure that all of the depositions, evidence, documents are collected that will be needed for that summary judgment motion. And so it's just a reminder that once you have decided to file this type of motion in any type of employment case, you want to make sure those documents, those depositions, that discovery has been completed and is ready to be used in any type of motion. The next bill that came out of the legislature had to do with discrimination claims. It was basically an amendment to the UNRRA Act and to FEHA that allows for discrimination claims based on a combination of characteristics instead of just isolated ones. This was already sort of the case in California law. It had been determined through case law and through the courts that someone could be discriminated against on the basis of two protected characteristics as opposed to just one. But this was the legislature clarifying and confirming that that was the intent of the UNRRA Act and the FEHA and putting it in the statute so that there's no ambiguity. And it's a big focus. It shows that the legislature is continuing to focus on intersectionality and DEI type initiatives. And so in California, at least, that those issues will remain at the forefront of these types of discrimination claims. SB 1110 makes it unlawful for an employer to discriminate on the basis of an applicant's possession of a driver's license or ability to get a driver's license. There is an exception, obviously, for if the job duties that the person is applying to requires that the employee would have to drive or have to use a form of transportation that requires a driver's license. But if it's a desk job or it's a type of job that doesn't require the employee to operate a motor vehicle, then that employer can't discriminate against an applicant based on the fact that they don't have a driver's license. AB 2499 has to do with California's victims of violence leave. California already had a victim of violence leave law, but this statute expands it and makes it unlawful for an employer to basically discriminate against people who use the victim of violence leave law. So that it also places the authority for enforcement of this law under the Civil Rights Department. So that means that now employers can be investigated or sued, potentially cited, and issued civil penalties for violating an employee's victim of violence leave rights. And so you want to be sure that your leave laws are being audited, that you're ensuring they're compliant, and that there's no potential for any CRD enforcement action in that area. It also expands the eligibility for this leave to not only employees who are victims of violence, but also to any other family member who is a victim of violence. And so you just want to make sure that if an employee comes to you and says, a family member of mine has been a victim of violence, I need to take time off, that you're ensuring that you're in compliance with AB 2499 when you consider that leave request. It also expanded the statute related to violence leave, which now prohibits an employer with 25 or more employees from discharging or discriminating or retaliating against any employee who is a victim, and can now be a potential cause of action that can be levied against an employer who violates this if they have 25 or more employees. So the previous slide applies to all employers. This one just applies to employers with 25 or more employees. So 2123 has to do with paid family leave. Prior to January 1st, before this law took effect, employers could require an employee to take up to 2 weeks of earned but unused vacation before the employee could start receiving paid family leave benefits. Under the new law, it's no longer allowed. That requirement is unlawful. So you have to allow an employee to receive their paid family leave benefits, even if they have potentially unused vacation time before. So it's sort of applying the paid family leave as its own benefit and its own leave provision separate from an employee's unused vacation time. And then the last one related to sort of leave programs is 2011. There was a small employer family leave mediation program. That program was not permanent prior to January 1st, but AB 2011 makes the Civil Rights Department's mediation program permanent and adds reproductive loss leave to the program. So this mediation program is available to both employees and employers to access permanently. And then you just want to make sure that you're ensuring that reproductive loss is added to your policies if you have that family leave program. And with that, I will turn it over to Andrea to discuss some more legislative updates.
Thanks, Sam. While we're making that transition, I did just see a question about whether it makes a difference if there's one employee in California, even if the total employees is above 25 outside of the state. That's a question we get a lot because California has weighed in on this in certain contexts. It depends on the law. But oftentimes California's position will be it's based on the total company, the number of employees in the company. But if you have a specific question, we can certainly answer that. I'll pass that back to Andrea. Thanks.
All right, thanks all. Okay, so in light of the recent natural disasters, we wanted to flag SB 1105, which went into effect January 1st. It allows agricultural employees to use paid sick leave days to avoid smoke, heat, or flooding conditions created by emergency, which has to be proclaimed by the governor, if those conditions prevent the employee from working. And in addition to that, the FAQs from the labor commissioner clarified that even under the prior sick leave law, avoiding hazardous conditions like wildfire smoke might be considered care or preventative care, entitling employees to also use sick leave to take time off. Okay, so moving on to minimum wage. So as of January 1st, the state minimum wage increased to $16.50 per hour. Meaning exempt employee salary thresholds are now $68,640 per year. There were also increases for specific industries. So, for example, April 1st, 2024, a fast food restaurant that is part of a national fast food chain had to increase its minimum wage to $20 an hour. And just to note, to be considered a national chain, the company must have at least 60 establishments nationwide. So just make sure that you're, paying employees these minimum wages, and you're also checking specific requirements for your industry. Always remember, there's also a lot of local ordinances on minimum wage. Most of them go into effect July 1st, 2024. So July 1st, 2025, you might see new minimum wages for your county or city. We listed some here, but always just check, your local ordinances to make sure you're compliant. And then for minimum wage, if you're, for the healthcare sector, if you're following what was kind of happening last year, there was a lot of statute passed about healthcare minimum wage, and it was kind of messy. The deadline to raise the healthcare minimum wage was pushed back multiple times, but then finally, after months of delay, California healthcare minimum wage increase took effect on October 16th, 2024, and hiked the wages up to $21 per hour for many healthcare facilities and as high as $23 an hour for some specific healthcare employees or facilities like dialysis clinics or larger healthcare systems. Here's a list from a chart from the DIR website reflecting the recent changes and what the changes are going to be in the future. Okay, so January 1st, 2025, the Freelance Worker Protection Act also took effect, and it affects how contracts need to be written between freelance workers and the hiring company. And a freelance worker means a person or entity composed of one person that is hired as an independent contractor to provide professional services. And here, when we say professional services, we mean things like marketing, administrator of human resources, graphic design, or anything else that's listed. There's quite a few under Labor Code 2778B2. Okay, so under the new law, the worker must be paid on the date or before compensation is due per the contract, and if the contract is silent, no later than 30 days after completion of the services. And then also, a hiring party cannot require a freelance worker to accept less compensation or provide more goods and services or grant more intellectual property rights than agreed to in the specific contract. And then just a few more things to highlight. So the contracts must be written. They must include things like the name, mailing address of each party, the itemized list of services that are going to be provided, the rate and method of compensation, data payment, and the date by which the freelance worker will submit a list of services that they've rendered under the contract. And then the hiring party has to retain these contracts for at least 4 years. Okay, so currently employers can voluntarily subject themselves to a social compliance audit. And AB 3224 just requires that employers who choose to conduct such an audit, they just have to post a link on their website to a report with the findings from the most recent social compliance audit. Okay, now I'll pass it back to Megan.
Thanks, Andrea. This Assembly Bill 1843 is another really good example of these kind of industry-specific pieces of legislation that we've been seeing over the last few years. This one expands an existing employee assistance program that applies to emergency ambulance employees, and it expands what's required to be provided to them. This, again, we just include this as a reminder that the California legislature remains incredibly active. They certainly do pass legislation that applies to a broader swath of employees, but it's really important to be looking out for those that might impact your industry in particular, as well as kind of see where there might be trends in expansions of rights for employees and what that might, how that might inform employers for the future. So certainly if you're impacted by this one, you want to take a closer look at that one. This next one, Senate Bill 399, this is one that applies much more broadly. So this one is the Freedom from Employer Intimidation Act, and it prohibits employers from taking adverse action against an employee who may decline to attend an employer-sponsored meeting or decline to receive any communication from the employer about that employer's opinions about religious or political matters. This is sometimes referred to as like the captive audience laws, and this is not California specific. We've seen these pop up elsewhere, where they're essentially saying you can't hold employees a captive audience, forcing them to attend a meeting where viewpoints of the employer are being shared. We sometimes see these happening around union activity, but the way that this one was written, it was focused on the religious and political matters that may be communicated by the employer about their own opinion on such topics. An employee who refuses to attend such a meeting, if it's required, must still be paid, even if they are not in attendance. There are penalties associated with a violation. This new law is enforceable by the Labor Commissioner. So this is something that could be investigated. Somebody could file a complaint, could be investigated by the Labor Commissioner. There are some exceptions. So if you have particular questions about the applicability of this, how it works, please feel free to reach out. And with that, we will transition to some of the important court decisions, and we'll try mainly to highlight kind of why these are important to employers, things for you to keep in mind in case this means you should add any reminders to your to-do list or anything like that. We'll start out, Sam will give us a high-level overview on arbitrations, since the courts are always continue to be very busy in this area. We just wanted to kind of draw out some of the key concepts that have come out of recent court cases.
Thanks, Megan. So yeah, as Megan just said, arbitration clauses in California are always an ever-evolving area of the law, constantly changing, and you always want to be up to date and make sure that you are in compliance with the latest case law related to arbitrations. So rather than going through individual cases and what they held, which can get kind of monotonous and boring, we decided to kind of summarize the latest takeaways from most of the arbitration cases in California. And so we came up with this list of 5 sort of big picture ideas that employers need to ensure that they are in compliance with their arbitration clauses. And the most important, and the ones that the courts have been heavily focused on most recently, is making sure that your arbitration fees are paid within the statutory window in CCP 1281.97. We have seen case after case after case from the courts upholding California's pay or waive arbitration statute. And so it is vitally important that the employer understand those deadlines and that they remain in compliance and pay those fees on time to ensure that the arbitration can go forward if the matter has been ordered to arbitration. Employers should also confirm that their arbitration agreements, especially in California, expressly state that it's governed by the Federal Arbitration Act. That ensures that in most situations, federal law will apply, which is a lot more arbitration friendly and employer friendly, and versus California law, which tends to be a little bit more anti-arbitration clause. So you want to have that in your arbitration provision, but you also want to ensure that substantively and procedurally, the arbitration provision matches federal law so that there's no argument that it's arguably a California provision. The third sort of takeaway is that the same waiver principles that apply to general contracts also apply to arbitration agreements. So you don't want to do anything as the employer to sort of give the impression or illusion or give employers counsel an argument that you've waived the right to compel a matter to arbitration. So just be aware of the actions you're taking, both in if there's a termination or there's some sort of claim that's arising that's leading to this arbitration, in that whole process, that you are aware of those waiver principles, and then especially in litigation. The fourth one is sort of related, which is don't delay a motion to compel or engage in discovery in court in litigation, because that could also give the illusion that you've waived your right to compel the case to arbitration. And you don't want the court to say, well, you know, we've been litigating this case in state court or federal court for 1.5 years. Why didn't the employer file a motion to compel 1.5 years ago? They waived their right. And so you just want to avoid the possibility of those kinds of rulings. Lastly, one of the biggest takeaways is that in California, especially, the circumstances surrounding electronic signatures on arbitration agreements continues to be scrutinized by the court. So there's a lot of cases out there holding various different issues related to an employee's e-signature and the authenticity of those signatures. So you want to make sure that you've documented the way that your arbitration agreements are signed, that the way they're distributed to employees, the way that you receive them, so there's no argument about chain of custody or about authenticity of the signatures on those agreements. And then just the last sort of arbitration point is that in 2022, Congress amended the Federal Arbitration Act by passing the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which generally renders arbitration agreements related to those issues as unenforceable. We've seen courts start to interpret this new amendment, and as you can expect, based on the statutory title, they are agreeing with the statute that certain types of sexual assault and sexual harassment claims can't be compelled to arbitration, even if the employer has some provision in their employee handbook or elsewhere that requires that. So just be aware of those types of issues and those types of court rulings that some cases related to sexual assault and sexual harassment might not be able to be compelled to arbitration, even though you might think that you have enough policies or enough notice the employee that they should be. The courts are ruling otherwise. So we'll move on from arbitration agreements and talk about some other cases that have come down from California courts in the last couple months. The first one is Applied Medical Distribution Court versus Gerald's. This was a trade secret case. And in this case, the jury found that an employee misappropriated their former employer's trade secrets, but simultaneously found that the former employer suffered no damages and the new employer was not unjustly enriched. So basically they found misappropriation, but no damages. Despite that finding, the Court of Appeal allowed the former employer to recover expert fees that it had incurred related to retaining a computer forensic expert, which was hired to help them stop or mitigate the impact of that misappropriation. And the court allowed them to recover those fees as damages. So despite the fact there was no unjust enrichment or damages related to the misappropriation, they were allowed to recover those as damages. The next case is Jones v. Riot Hospitality Group. This is about spoliation, has some interesting facts. This case is actually out of Arizona, but the Ninth Circuit issued a ruling on it, so we included it in this update because the Ninth Circuit law applies to California as well. This plaintiff had sued her former employer for discrimination, and the plaintiff was ordered to produce text messages that she had engaged with coworkers at the company. She failed to produce those, and so the district court ordered a third-party expert to search plaintiff and coworkers' phones. And that expert forwarded the text messages to plaintiff's lawyer. And the lawyer nonetheless failed to produce the text messages to the employer. The district court then ordered the expert to send the messages directly to the employer's counsel, who looked at them and thought that there was not enough text messages in the production. And they had the expert review the messages that had been given, and the expert basically submitted a report saying that there was an effort to delete or hide evidence subject to the court's order. And so the court actually decided to dismiss the case, which is a really drastic sanction imposed by a court. And the Ninth Circuit said that that was actually the proper determination, and that the district court acted properly in imposing a termination sanction, because the deletion of the text messages with coworkers and her coordination with witnesses to delete their text messages was prejudicial to the employer. This really highlights, despite the fact that this was a plaintiff and not the employer doing this, but it really highlights the importance of making sure you have litigation hold memos at the beginning of a case, that you're ensuring nothing is being deleted or destroyed or lost, and so that you can then show a court, if it comes to something like this, that you've taken every step possible to ensure that the evidence is there, that it's able to be produced if necessary, or if ordered by a court. So just highlighting the importance of those initial sort of immediate actions you need to take once you receive notice of a lawsuit. And with that, I'll turn it over to Andrea to discuss some more case law.
All right, so now we're going to go over a case that's about the exhaustion of administrative remedies. It's Cooey Goa v. Department of Veteran Affairs. So here, the plaintiff filed a complaint with an anti-discrimination agency, the EEOC, and a court. So, and the complaints told different stories. He essentially asserted things in his civil suit that were not identified in his agency complaints. The employer moved for summary judgment, alleging that the plaintiff did not exhaust his administrative remedies. And the trial court granted summary judgment, and the Court of Appeals affirmed, noting that by withholding facts from the agency, the plaintiff essentially deprived the agency of the ability to investigate the alleged wrongs that were the focus of the civil suit. So, just be sure to review agency complaints that employees filed to see if there are facts in the civil complaints that have been left out of the agency complaints. And if there are, you may have a good chance at summary judgment. Okay, so the next case is Lusardi Construction v. DIR. So here, a school district awarded Lusardi, the contractor, a contract for a construction project. And then Lusardi contracted with a subcontractor to assist with the project, which is totally normal. But here, the subcontractor failed to hire these apprentices for the construction projects, which were required by law. Because I guess there's a certain apprentice to journey person ratio that needs to be met. And the Court of Appeals found that the contractor and the subcontractor were jointly and severally liable for the penalties due under the labor code, even though only the subcontractor was really one violating the labor code. It should be noted that this labor code, it's 1743, it states specifically that contractors and subcontractors will be jointly and severally liable. But there's a lot of similar laws that also state joint and several liability. So it's important, just when you're working with subcontractors, you're aware of what they're doing and that they're following the law. So the next one is more about wage and hour claims. So this is it's Huerta v. CSI Electrical Contractors. So here the facts are important. The employees had their vehicles checked when they arrived at work, and the security checks included things like scanning the employees' badges, going through a visual inspection of their cars, and the employees allege that the inspections, they had to wait in line, and the whole process could take up to like 30 minutes. Then, after the security checks, employees allegedly had to drive another 15 minutes on the employer's property before reaching a parking lot. And then during this time, employees had to comply with certain company rules, like, going the speed limit, no drugs or alcohol policy, harassment policy. So the court had two important questions. Was the time spent going through the security check compensable? And then was the time spent driving from the security check to the parking lot compensable? So the court found that an employee's time spent on the employer's premises awaiting and undergoing the employer mandated security check is compensable as hours of work. And that really had to do with a high level of control that was specific to this case. And the court noted that, simply scanning your badge or having to, to like enter or exit a parking garage wouldn't be sufficient control to require compensation. The court also found that the time spent driving from the security gate to the parking lot was not compensable just because the employees were subject to some general rules about being on the premises. And the court essentially said that, finding an opposite finding here would be too broad and unworkable, which is, a win for employers with regards to that. It also noted, however, that so employers in construction, drilling, lodging, and mining, we just want to flag that the court noted that even though drive time did not have to be paid for hours worked, that time may be considered employer mandated travel under wage order number 16, which only applies to the industries I just mentioned. So if you're in one of these industries and you have, and you have a long drive to your parking lot, you may want to think about, reviewing wage order number 16 or paying employees for that time. Okay, so the next one is Naranjo v. Spectrum Security. This case has been around for a while. In prior proceedings, the court found that the company owed wages for unpaid meal and rest premiums. And so Labor Code Section 226 requires employees to issue wage statements to employees that include things like gross and net wages earned and a bunch of other information. And knowing and intentionally failing to provide accurate wage statements can lead to penalties. So here the company faced penalties under this labor code because its wage statements did not record the unpaid meal and rest break premiums, which are now considered wages under the law. But at the time the wage statements were issued, it was unclear whether such premiums were actually considered wages. A prior decision in this matter, in the Naranjo matter, is the decision that actually established that meal and rest breaks premiums are wages. So here, the Supreme Court found that an employer's objectively reasonable good faith belief that is provided employees with accurate wage statements preclude an award of penalties under Labor Code Section 226. But a mistaken belief, and this is true kind of universally, a mistaken belief of law is not a reasonable or good faith belief. So this is now available as a defense for companies who did not comply. If you have a pending wage and hour lawsuit, kind of from this time period. All right, now I'll hand it back to Megan to finish up the case law.
Thanks. We had a couple of PAGA cases come down before PAGA reform took effect. So first we had one early in last year that resolved a split amongst the Court of Appeals, and this found that the trial court lacks inherent authority to dismiss a PAGA case based on manageability grounds, which is an argument available in the class action context. And for a brief period of time, it was an argument that employers could make in the PAGA context, but that argument is available no longer. And then we had another case come down from the Supreme Court that held a plaintiff in a PAGA action does not have a right to intervene in the PAGA action of another employee, or to move to vacate a judgment in another case, or to consider objections to proposed settlement in that action. So it's often the case that we see competing PAGA actions. There might be multiple covering the same period of time or the same employees. And so employers kind of struggle with how to manage multiple cases at the same time. So that's where some of these arguments have percolated through the court system to see how they can be managed, how they might be able to be coordinated. So with this decision, we see that there may be more pressure to race to a settlement, since employees in another competing PAGA case can't simply rely on the ability to insert themselves in a different case if they want the benefit of the settlement in their case, and there's been a settlement reached already in another case. So it may alter the litigation strategy of the plaintiff's bar. We'll see, but it is something for employers to keep in mind as well. Then transitioning a little bit to discrimination, hostile work environment cases, we had a case come down again from the California Supreme Court, and this one actually reversed a summary judgment decision. It reversed the grant of a summary judgment in favor of employer, and the Supreme Court found that an isolated use of a racial slur may actually constitute sufficiently severe conduct to create a hostile work environment under the Fair Employment and Housing Act. And in this context, we look at the law that requires that discriminatory behavior, hostile work environment case has to rise to the level of either being so severe or pervasive enough to establish a violation. So here is an example of where a single incident was severe enough in the Supreme Court's viewpoint to constitute a hostile work environment. And the circumstances of this case were really critical to the Supreme Court's analysis. And they took into consideration that there was a management level person involved, and that there was a complaint to management such that the employer was really aware of what was going on. And there were criticism of how that report was handled. So this is, again, a good reminder of what the standard is, and that, yes, it is true that a single incident could, under the right circumstances, be severe enough to constitute a hostile work environment. Though we typically see cases where there's multiple actions and where the case is decided on the pervasiveness of the activity, this the category of severe is still something for employers to be aware of and manage. And then we had one more, which is a really interesting case in the context of third-party liability. So this is Mobley versus Workday. This is still working its way through the court system. This was a decision that came out from the Northern District of California. There was a motion to dismiss filed. So this was early on in the case, and that's why this case is still going on, and there may be more to learn down the line if there's a decision made on the liability side. But for the purposes of early on in the case, deciding whether or not this case could continue through to litigation, there was a question of whether a third party service who is being used by the employer to screen applicants using AI resources, if there could be liability tied to that third party. And there were a couple of theories put forward. One was rejected, which was an employment agency theory under federal law. They rejected that, but they did say it was able to get through and continue because they found that Workday qualified as an agent because the tools that it was using was performing a traditional hiring function of screening and rejecting candidates, recommending whether they should advance to later stages of the application process. And one of the things that was unique about this case is that the plaintiff filed dozens and dozens of applications and was getting rejected, sometimes automatically, and sometimes, if he submitted an application in the middle of the night, he would get an auto reply within a couple of hours. And so the technology that was being used, there's a question about whether it in and of itself is discriminatory, and whether the employer and that third party agent can be held liable for that alleged discrimination. Really interesting case to keep an eye on for the future. And with that, we are nearing the end. I'll pass to Sam to give us a brief NLRB update, and then we will wrap up for the day.
Thanks, Megan. So sometimes it's easy to forget, based on all the stuff we've covered in this presentation, that the NLRB and the NLRA does apply to California. Employers have to comply with the NLRA and the NLRB decisions, and we have so much case law and legislation in California that it's easy for the NLRB to be forgotten. So I just wanted to quickly talk about some high-level updates that are happening with the NLRB. Since the Supreme Court's decision in SEC versus Jarkissi last year, which held that the SEC enforcement actions that employers subject to those proceedings are entitled to a jury trial, there's been numerous quote-unquote Jarkissi challenges filed against different federal agencies on the same theory. And that theory is that, one, the board members that decide these types of cases are improperly insulated from removal by the president. The ALJs who decide the cases in the initial stages are also improperly insulated, and that because these administrative proceedings violate the employer's right to a jury trial. And so what we've seen in the last month or so is that the general counsel of the NLRB has been removed by the president. An NLRB board member has been removed by the president. And so these are sort of like the examples of the NLRB constantly changing from administration to administration. I think oftentimes we see policy changes across the government, but the NLRB is significantly more sort of tied to the administration's motives and goals in directing policy. And so in the last week, the new acting general counsel has revoked a bunch of memos that were issued by the prior general counsel. And so it's really important for employers in this space to ensure that they're up to date and in compliance with the latest directives from the NLRB, from the general counsel, and from any case law. The corollary issue to all this is that because that board member has been removed, there's right now not a quorum at the NLRB. And so there's really nothing, there's no new cases that can be heard by the board or new decisions that can be issued by the board. And so everything at that level is kind of at a halt right now until the issues related to the removal of that board member are resolved, probably by courts, because the board member is currently challenging that removal. So just a reminder that the NLRB especially, but federal agencies are constantly changing. And as if employers didn't already have enough to focus on in California, then you have the federal level changing. And so there can be a lot to unpack and a lot to follow related to all of this. And this stuff, the removal of the board member, the removal of ALJs, that's an extremely fluid situation right now. It's making its way through the courts. There's been circuit splits across the country, and it looks like it could be set up to eventually end up in the Supreme Court. Obviously, we'll see whether the Supreme Court decides to take any of those issues or those cases. So with that, I think I will send it back to Megan to just wrap up, talk about overall takeaways, and thanks everyone for joining us.
Thanks, everyone. So this year, since we have such a wide range of issues that have cropped up, we did want to kind of provide some high-level takeaways for employers to see like what might they have on their to-do list for the coming months to make sure that they're in compliance with all of these things. One thing that we encourage employers to do periodically, but particularly now given the landscape and given the changes that we've already seen and that we're anticipating, is taking the opportunity to review your policies, procedures, handbooks, and the like to make sure that they're up to date. California is just one of those states where we see changes regularly, and they don't make it easy on employers for sure. Sometimes the updates come mid-year. You'll see a July 1 change for some of the minimum wage. You'll see a new piece of legislation with an effective date somewhere in the middle of the year. And then some of those changes go into effect January 1st. So they certainly don't make it easy for employers, but to have a regular review of these things it can be really helpful to make sure you're up to date. Ensuring that your postings and other communications to employees are up to date. Each law in California, if there's a requirement for a posting or there's a requirement to provide a California agency form to employees or communicate something to the employees, perhaps that could be done through the handbook. That is all dictated by California law with specific requirements. So making sure that you're in compliance with all of those. Kind of on the PAGA front, the class action front, making sure you're doing your wage and hour or even other employment law audits to ensure compliance. The other thing that came out of the recent wildfires is, a reminder to make sure that you're prepared in case of unexpected things that happen. One of the questions, that we got is, when people are in an emergency and dealing with things on a very rapid basis, responding to employee questions, is kind of knowing what policies could be implicated, what policies are in our handbook, what benefits do we provide our employees, and when do those apply, and how do we execute on those in an emergency situation where our employees may be impacted, but also our higher level folks, our managers, our supervisors may be impacted by these things as well. And then again, just remembering that California law is in constant flux. And so being able to be nimble and adjust when you need to. With that, we want to say thank you so much for attending. Thanks for everyone's attention and questions. We will be sharing a copy of the slides and the recording as well, but reach out with any questions. We've also included our 2025 labor and employment webinar series, so you can see what's coming down the pipe. If you want to register for those, then even if you aren't able to attend, you will receive the copy of the recording so you can listen to it on your own time. We also wanted to share, we have a California specific OSHA webinar series that's out, and we from time to time will do a crossover between either our national practice or our labor and employment practice. If you have any requests for our webinar series, feel free to reach out. And I will leave with our contact information in case you have any remaining questions or want to reach out. Thanks again, everyone. Have a great day.